Good afternoon. Why don't we get started? Welcome to the first of Venable's summer series of nonprofit seminars, and welcome to our approximately 450 people on the webcast. So that's a great attendance for the summer. For those of you here in person, welcome. It's great to have you. So let me introduce today our panel. Our topic today, as you know, is legal structuring for nonprofit organizations, creating systems, affiliates, and subsidiaries. I'm Bob Waldman here at Venable in the nonprofit group, along with my partner, Yossi Ziffer, also here from Venable. And I am thrilled that our guest speaker and featured speaker, Don Blanchard, Chief Executive Officer of the Whitman Walker Health System, who has actually been down the journey of forming a system with us, and I was thrilled that he would take my call, much less agree to speak at this event, but we're absolutely thrilled to have him with us today. Before we start, just a couple of things. For those of you who are here in the room in person, there are two microphones on either side. You should feel free at any point in time this afternoon to get up, and if you have a question you want to ask, or at the end we'll also take questions at the end, whichever you prefer. For those of you who are on the webcast, I know there's a process for submitting questions from the webcast. For those of you, if you would, with those, we'll deal with those at the end of this. You should feel free to submit your questions, and we'll deal with those at the end of the talk. Just a reminder, we do these conferences. We've been doing this now for a number of years. It's a lot of fun, and we hope we've provided some education in doing it. We'll have another one. Our next one will be on July 18th, where Melissa Steinman and Annie Lee of our firm will be discussing maximizing your native advertising and use of social media influencers for nonprofits. So we'll send reminders out of that, but please mark your calendars for that one. So why don't we get started then? So as I mentioned, we're going to talk about legal structures for nonprofit systems, when to add affiliates, when to add subsidiaries. We know that, and we know this from our practice, that many nonprofits are in the process of considering or have added additional entities, perhaps creating nonprofit systems, perhaps just adding one subsidiary to it. And we want to talk today about what are the different possibilities and what's the thought process that you should be going through when you think about, should we add another entity? Should we create some sort of system? So where we start with is thinking about why do it? Why do it at all? What are the reasons for adding entities, for thinking about creating some kind of system? And there are a number of thoughts that you should take into consideration. The first reason that you usually hear for someone wanting to add an entity is they're undertaking a new line of business. We're going to add something that we weren't doing before. It's different than what we were doing before. Maybe we should do it in a different entity than the one we currently have. Second, we'll hear people say that they're getting involved in something that has some legal risk to it. It's an activity that maybe they haven't done traditionally, but they think involves either the possibility of, maybe there's personal injury possibility, you're getting into some kind of business where someone might actually be injured, or you think, well, we're now providing technology or we're providing information, maybe there's some risk about IP infringement we're worried about, maybe we're worried about that if whatever it is we're selling or providing doesn't work or something goes wrong, we could be liable for it. So maybe that's a reason to start to think about putting it in a separate entity. Another reason we hear is we just want to separate functions. We're a nonprofit that now has different lines of business, and we've been doing all the lines of business in one organization up until now, but maybe we should be doing it in a separate entity for simply to segregate functions. And that's something we'll talk about. We also hear that a reason that we may need an additional entity or entities is we need different types of boards of directors that with different skill sets. Today, we're a nonprofit that has one board of directors, and the people on our board have a variety of skills. Some of them are there because they have a special expertise. Some of them are there because they're donors. Some of them are there because they have access to information or they have access to other fundraising possibilities, but they're all on the same board. And what people will say is, that's not necessarily the most efficient model for us because we may want on one board people who really understand how to run the operation. We want operational people on our board. But we've got another function that's a fundraising function over here. And maybe what we want there is people who have access to fundraising. Either they themselves are donors or have access to donors. But we really don't want them involved in the running of the day-to-day business. That's not their expertise. That's not what they do. So maybe we need separate boards. One board that's a fundraising board, another board that's an operational board. Maybe we have another board that has a particular expertise. But again, another reason for possibly creating additional entities with additional boards. Another reason to think about adding entities is your organization is getting involved in an activity that perhaps presents a risk to the 501c3 tax-exempt status of your organization. Your organization is a healthcare organization. And you're going to get involved in an activity, let's say it's a consulting business, or it's a technology-based business that maybe trades on some of the expertise that your organization has developed in its nonprofit life, but that what you're actually doing looks very much like a commercial activity. In our nonprofit life, we've developed some technology that is just great. We think this is great technology. It's incredibly helpful to our organization. But you know what? We'd like to share it with the world for a price. We want to sell that technology. We want to license that technology. So now we begin to look like every other for-profit seller of technology or licensor of technology. And if we keep that activity inside our existing charitable 501c3 organization, maybe we present some risk to the 501c3 nature of our organization. And we want to move that into a different entity, maybe a for-profit entity, because we think that presents some risk to our 501c3 status. Another reason for possibly considering additional entities, and this is one we're seeing more, as nonprofits grow and start to add other entities, maybe you need one entity that provides centralized management and a centralized vision for the organization. You're a nonprofit that maybe has 3 entities in it right now. Maybe you've got, let's use a simple example. I've got a religious organization. Maybe there's a church. In a separate entity, we have a school that's affiliated with the church. And maybe we have a third entity that does some sort of home care. And they're all operating on their own and doing whatever it is they do, but we need an entity that's going to coordinate this. We need an entity that's going to make sure everyone's got the same mission, everyone's got the same vision, that we're allocating resources effectively between those entities. We need somebody to run this system. And that's something where we might think about adding another nonprofit parent type entity, very commonly seen in hospital systems where you have each hospital in a separate entity, but you need a parent to sort of make sure they're all operating in sync. And the other reason that we think of as why would we start creating more entities is tax planning. Sometimes we're afraid that an activity contained within our existing structure will create unrelated business income, or there are adverse tax reasons. So we're going to think about maybe moving that into another entity to create better tax results. Now, as we start to think about adding entities, possibly even creating a system, what do we need to think about? First of all, we have to think about liability protection. And as we say, is it real or is it perceived? And I'll talk about that a little bit more in a minute. But we want to think about, is putting this activity in another entity going to provide real protection for the organization? Second, and one that is very complicated and difficult, and for any of you who've ever been through the exercise, I'm sure would share that feeling, is board structure and governance. How are boards going to be selected? How are boards going to be? How big should the board be? Who's going to decide who's going to be on the board? And how do we exercise control of the system? Once we start adding more entities, how do we have a governance structure that's going to make sure one of them doesn't walk away, or one of them doesn't go rogue? How are we going to do governance of this organization? We're going to think about, as we create entities, how do these things qualify as 501c3 organizations with the IRS? And what's their IRS classification as a public charity? And for those of you who've ever been through that whole analysis of the different types of public charities, and Yossi will talk about this in a minute, we need to think about what is the right classification for each of those entities. Again, as I mentioned, we need to think about, as we create entities, are we creating tax issues for ourselves? And sometimes, and again, we'll talk about this in a bit, sometimes when money flows from a subsidiary organization back up to its parent, sometimes when that money, which normally would not have been taxable, when it comes through a subsidiary back up to the parent, in some cases can become taxable. And we'll talk about that in a little while. But we want to make sure, as we structure entities, that we're taking into consideration tax issues. An important practical issue are employee issues. These are probably, in some ways, the most important. Because as we add entities, we have to figure out, where are people going to work? Who's going to employ them? Is each entity going to have their own employees, or are we going to have one set of employees? And I'll tell you that it's very common to have all the employees in a system in one entity, who are then parceled out to the other entities. And there are various structures to that. Sometimes the other entities lease those employees. Sometimes there's a series of chargebacks in them. But the reason you're going to want, while you think about why you want all the employees in one entity is, do you only want to run one payroll? If you start employing people at different entities, you're going to be ending up running multiple payrolls. And also in terms of employee benefits. Let's say we have a 401k plan in the existing entity. As we move employees to other entities, are they going to have to adopt their own 401k plan? Are they going to have to get their own health insurance? Will the insurance company let them participate in the existing insurance program? So those are important issues to think through. Intellectual property issues, particularly trademarks. As we add more entities to the system with similar names, we may have the X institution and then the X foundation and the X real estate. Who's going to own the trademark to that name? And how are we going to license it to our other affiliates? And then we need to think about the costs of adding additional entities. People come in and say, oh, I want this and I want more entities and I need a subsidiary and I need a foundation. Well, you got to think about, what is that going to cost in terms of additional time, accounting, legal, IRS compliance? People think that, the more the merrier. But a lot of times what you'll find is that at the end of the day, the cost of running multiple organizations outweighs the usefulness of them. And I've seen numerous examples where people will say they've added all the entities and they go at the end, I wish I really had never done that. It's just become, I had enough problems running one organization. Now I've got to run 3, and I just don't have the bandwidth to do it. So let's go back and talk about liability protection and the reason for setting up separate entities. And, the adage is that if I put something in a separate entity, liability will be locked within that entity. And there's a lot of truth to that. If I have a risky operation and I move it into a separate corporation, is that better than having it in my existing corporation along with all my other activities? The answer is, yeah, it's better to have it in a separate entity because you've moved the liability to a different entity to an extent. But in deciding whether that liability protection is real, and we'll show you some models later on, you have to be careful of a couple things. The first is what people refer to as piercing the corporate veil. If two corporations look too much alike and in effect act as the alter ego of each other, that there really is no real true separation, it is possible to, quote unquote, pierce the corporate veil, in effect to collapse those two entities and say, we're not going to buy the separation of those entities. That even though you've put this other activity in a separate entity, that's not real. It's operating exactly like the other entity, and we're going to collapse the two. And what that really means is if you're going to set up a separate entity for liability protection purposes, then it needs to have a separate board. Now, can that board be identical can all your boards be identical? Well, they could be, but the more identical they look, the greater the chance somebody collapses the organizations. If I have two entities and they have identical boards and identical management, it begins to look like they're the same entity. So it's important to have separate boards. There can be overlap. We can be overlapping boards. You can have some of the same people on each board, and we'll talk about this a little bit more later. We will suggest that in a perfect world, you would not have more than a minority overlap. So if you have seven board members on each board, we would suggest it's best to only have 3 overlapping on each board. It's important to keep separate corporate records, have separate meetings. Again, you don't want the two entities to look like they are the same entity. Mentioned board structure and governance. So what do I want to be thinking about as I add entities? I want to think about the size of the board. And I would tell you that the current trend is smaller boards. And you probably are seeing this in your own lives, that boards that are too big become unwieldy, hard to get, it's hard enough to get a quorum to do anything, hard enough to get a meeting, hard to get people to show up, hard to get people involved. So I would say the trend is towards smaller boards, but different entities in a system can have different size boards. Again, as we mentioned, you can have overlapping board membership, but again, as we suggest, it's best to keep that overlap to a minority. You have to think about how are board members going to be appointed? And this raises a number of issues. There are a number of models that you could do. Typically, what you would want is to have the parent entity in the system appoint the other boards. That way, it gives you some level of control. The parent's controlling. It appoints the boards. It removes the boards. But you have to be a little bit careful, too, because you don't want the subsidiary boards to feel disenfranchised. If they feel like there's too much power in the parent, they feel like, why am I here? I really can't do anything. Now, it is very common in a parent-subsidiary structure. It's very common to have in the parent what are referred to as reserved powers, where the subsidiary is permitted to do some things, but important decisions, really major decisions, can't be done without the approval of the parent. That's referred to as a reserved power. And in the corporate documents of both the subsidiary and the parent, you'll outline those reserved powers. That if the subsidiary wants to merge or wants to go out of business or it wants to take on substantial debt, then it needs the approval of its parent. But there are a number of board structures. We'll talk about some in a minute. But we have to think about how are the boards of the subsidiaries going to be appointed. You could have a situation where the subsidiaries appoint their own boards, but that runs the risk that they will go rogue and walk away. What we're seeing more of, and Don will certainly talk about this in his experience, are nominating committees. And the nominating committees could have representation of all the various entities in the system who put names in front of the parent board. That gives the subs a chance to participate in the process. But there are a number of ways to do this. Now, you should also think about in board structure, as we mentioned, what special qualification and skills do you want for particular boards? So if you have, for example, a foundation board, that's a fundraising board, maybe that board has mostly people with fundraising acumen on it. If you're going to have an investment entity in the system, one that just invests the organization's endowment, you may want people with investment expertise on it. On the board of the entity that's actually going to run the operating charity, you're going to want people who actually understand the business, who understand what are you trying to do and how does this business run. It's not that useful necessarily to have someone who's got just fundraising expertise to be on that board. There's a place for that person, but you need to take that into account. And then you need to be careful in structuring these boards about avoiding what we refer to as meeting fatigue, which is you create multiple entities and you got the same people, or some of them, on all of it. And they go, I'm going to 20 meetings. I can't go to 1 million meetings. I can barely handle going to one meeting. You're wearing me out here. And so to be careful about meeting fatigue. What we've seen done, and a lot of people do, is they'll have all the meetings at the same time, where on one day they'll have, all right, we're now meeting as the parent. Then everybody flips the card, and now we're meeting as sub one, and everybody takes off one hat and puts on another hat. The other thing that I think about in governance is the use of what we call joint committees. Rather than having each entity have its own committees, each one having an audit committee, each one having a finance committee, each one having an executive, you have a joint committee of all the entities that perhaps has representation of all the entities in it. Let me turn this over to Yossi now, who will now talk about some of the different types of entities that you can use in creating systems.
Thanks. So as Bob said, once you've made the decision that your organization's needs merit some type of expansion or restructuring, question then becomes, okay, so what are the tools in the toolbox that I can use, right? What's the right fit in order to plug in these additional players into our expanding structure, into our expanding system, in order to best carry out the objective that we're seeking to achieve. And as we have listed here on the slide, is certainly not an exhaustive list, but these are certainly a lot of the candidates or types of organizations that you would expect to find. So certainly when you're dealing with your existing organization already as a 501c3, your new affiliate, wherever it's going to fit in the structure, may also qualify under Section 501c3 as a charitable, educational, scientific, etc. organization. We'll speak a little bit about those specifics. 501c2 and 501c25, those are really two variations on one theme of what's called a title holding company. Those entities most often are associated with real estate ownership, although at least for 501c2, not exclusively, and we'll speak a little bit about those details. Supporting organizations are a variation under 501c3, and particularly within the system structure, a supporting organization may have an important role to play. Single member LLCs are increasingly common and useful for their flexibility in terms of being able to play different roles, and they somewhat overlap with the C2, C25 title holding companies for certain purposes. And then for-profit subsidiaries, going back to the scenario that Bob described before, where the activity that is justifying the formation of this new organization may actually be outside the parameters of what your tax-exempt entity can do consistent with its tax-exempt purposes. And so if that's what's motivating the creation of this new entity, then introducing a for-profit subsidiary may be appropriate and may also offer certain opportunities or possibilities that were not available to your tax-exempt organization. So let's go through each of these categories and just discuss a few high-level details. So when you talk about if your flagship entity, the entity that you start with, is already a 501c3 organization, you might say, well, why would I go and create another one? Couldn't I just simply do multiple 501c3 activities out of my existing entity? And in some instances, the answer is yes, you could. And for the various factors that Bob mentioned, maybe your new activity doesn't justify the formation of a new entity. But often, if the new activity or new function really is distinct from what your existing organization is known for, what it's associated with, then a new 501c3 organization can be appropriate. And as we say here, particularly within multi-entity systems where you have different, say, schools or hospitals that maybe service different geographic areas or communities, but they're all part of one integrated family of systems. So as you expand into new neighborhoods or new cities, new communities, you might form a new 501c3 to really carry on your existing activity, but in a way that's targeted and specialized to that new community. Another reason to form a new 501c3 organization is if you're really going to expand your fundraising operation and you want to isolate that from your operations. Again, along the lines of what Bob said. If the fundraising arm is now going to have its own management, its own governance, and its own professionals, well, certainly the entity that's going to be doing fundraising has to be a 501c3 in order to access grants from foundations, deductible contributions from individuals and companies, right? All of that fundraising function really presupposes that the entity conducting those activities will be a 501c3. And the third point here is that if an entity is going to hold the endowment of an organization separate from the operations, then that entity too can be formed as a 501c3. And not to overstate the obvious, but the two principal benefits of having 501c3 status are A, that contributions will be deductible to the donors, and B, that the revenues and income earned by that organization will not be subject to tax. Certain other benefits may come along as well. What's important to note is that in addition to the corporate process of forming the new entity, which typically involves some filing with the state where the entity is located, as well as the development of proper corporate documents like the bylaws and any other policies, the new 501c3 organization will need to apply to the IRS. So we're talking about a separate tax ID number and then a separate application for recognition of tax-exempt status filed with the IRS. There's no, generally speaking, with some exceptions, there's no way to migrate your existing 501c3 tax-exempt status to the new entity. And therefore, you're talking about sort of a new point of contact with the IRS where you disclose to the IRS, this is the new entity being formed, this is what we're going to be doing, and hopefully that process results in a favorable determination letter from the service recognizing the new organization as a 501c3. But in planning out the process of a reorganization, just the time associated with going through those steps, both in terms of formation and then qualification, should be taken into account. We said before that for some planning purposes, you may want to form a title holding company. And we've given two examples here of 501c2 and 501c25. Generally, these types of entities are associated with the ownership of real estate. And so here you're not talking about an entity that's going to be conducting fundraising, but it is going to hold title to this property. So again, in terms of balancing those different factors that we've mentioned before, by moving the real property into this new title holding company, you've achieved one of those objectives of isolating liability, right? Certain liabilities sort of are typically associated with real property. Someone falls and gets injured, or there's some other type of legal claim associated with this real property. By housing it in a tax-exempt title holding company, sort of maintaining the benefits of tax-exempt status that you had from your existing organization, but you've segregated the liabilities associated with this property in this new entity so that the assets in your operating entity are not directly exposed to claims by any parties who might be raising an objection. As between 501c2 and 501c25, they are largely the same, with a couple of important distinctions. A 501c25 can only exclusively hold title to real estate. 501c2 technically could hold title to other types of property besides real estate. Now, in practice, more often than not, you would use a C2 for real property as well. But one of the reasons that this distinction becomes important is if that real property is actually being held through a joint venture. So if you have a joint venture with a developer, let's say, who's going to have some stake in developing this property and then a share of the revenues generated by the property, and you want your organization's share in that joint venture to be held by a tax-exempt title holding company, well, then you have to go the 501c2 route rather than C25, because from a technical legal perspective, what that title holding company entity is holding is not an interest in real estate, it's a partnership interest. It's an interest in the joint venture entity that has been created with the developer. So that can be one important distinction. On the flip side, 501c2 is stricter than 501c25 when it comes to incurring unrelated business taxable income, having to pay UBIT. Now, one of the ways that that an organization winds up owing UBIT is if the property is financed with debt, if there's a mortgage on the property. Debt-financed income won't be a problem for either of these entities. But if for any reason there's some other type of UBIT-generating activity associated with this real property, you would have to hold that through a C25, not through a C2. The incurrence of that sort of pure UBIT would undermine the tax-exempt status of a 501c2 entity. We mentioned here as well that these entities, just sort of as part of the rules of the game for qualifying as one of these types of title holding companies, they can't stockpile the revenue that's generated by the property that they own. They have to turn around and pay it out to their tax-exempt parent, and that really goes to show the fact that these entities are operating consistent with the overall objectives of the tax-exempt parent. Not to skip around, but we mentioned, and we'll come to it in a moment, the concept of single-member LLCs. I would say that in practice, the availability of single-member LLCs has somewhat marginalized or decreased the frequency of use for these types of tax-exempt title holding companies that are formed as corporations. You can really achieve a lot of the same benefits of protecting yourself from liability, of isolating liabilities through the use of a limited liability company without having to go through the process of forming a corporation and qualifying it as one of these types of 501c entities. Let's talk now about supporting organizations. And we mentioned before that if you're starting with a 501c3 entity and then you're sort of building out within the network or within the system of that organization, there are many cases where you will want your new entities to also qualify as charitable under Section 501c3. Now, as you may be familiar, although everyone talks about 501c3, that's like the one section of the tax code that everyone knows. There are actually subcategories within 501c3, and the fundamental distinction that you encounter is this distinction between public charities and private foundations. And there are some, the default, if barring anything else, is that all 501c3 organizations are private foundations. But then there are a bunch of ways that you could opt into qualifying as a public charity. And the reason that distinction matters is because there are a set of rules in Chapter 42 of the Code that apply to private foundations that, by and large, do not apply to public charities. File a different tax return. There's some excise taxes that are imposed on private foundations that are not imposed on public charities. There are various reasons. private foundations, very important players and often the right fit for an organization. But if an organization sort of finds itself, being able to choose which way it's going to go, the private foundation route or the public charity route, there are often certain benefits and a little more flexibility associated with being a public charity. So how do you get there? So some organizations just per se automatically are public charities. Those include churches and other religious houses of worship, schools, tax-exempt hospitals. Those organizations, just by virtue of what it is that they do, the tax code treats automatically as public charities. And then you have this other group of organizations that achieve public charity status because they generate their financial support in large part from the public, either through fundraising, sometimes through the payment of certain types of membership dues, or through actually providing goods and services in a charitable manner such that the revenue that they earn from providing those goods and services is treated as public support in achieving public charity status. Then you come to supporting organizations. And supporting organizations are another way for an organization to not be treated as a private foundation, to instead, for most purposes, to be treated more like a public charity. And as the name suggests, a supporting organization derives its status as a form of public charity because it provides support to an existing public charity. So it's formed as a separate entity, it's a separate 501c3, but its role and purpose really is to take on certain responsibilities or to play certain functions with respect to another organization that independently qualifies as a public charity through one of those other means that I described a moment ago. And so the benefit there is that if you're forming a supporting organization, it will qualify as a public charity without having to pay attention to who are our donors, where are we earning our money from, do we have enough diversity among our donor base, enough distinct donors to pass one of the mathematical tests that are imposed on these publicly supported charities. Supporting organization, as long as it qualifies as such, is automatically a public charity without having to meet those tests. There are different forms of supporting organizations, primarily three types that the IRS has creatively named: Type 1, Type 2, and Type 3. And those three forms of relationships really come to the structural relationship that exists between the supporting and the supported organizations. Type 1 is what you would call a parent subsidiary. Type 2 is where the supporting and supporting organizations are brother-sister organizations where they have the majority overlap of the same folks on each of the boards. Type 3, a little more amorphous, what we say is a more attenuated relationship, and there are some additional subcategories and nuances within Type 3 that are probably beyond the scope of today's discussion. But suffice it to say that in forming a supporting organization, you're going to be thinking carefully about those structural issues that Bob mentioned before in terms of what is the interlocking relationship between the board of our new supporting organization and the charity or charities that it supports. And as we mentioned here, often when you're talking about creating a parent entity in a system, that parent entity that has that oversight role, sort of looking from the top down to its various affiliates and exercises that control, making sure that everyone is rowing in the same direction, that parent entity will often be classified as a supporting organization. We mentioned single-member LLCs before. LLC, limited liability company. It is not a corporation, at least by default, although it could elect to be taxed as such, but it's a different form of entity. And because it is because here what we're talking about is an LLC with just one member, it is not treated as a partnership either. And single-member LLCs, well, again, as the name suggests, so there's one member. So here what we're talking about is your 501c3 organization forms a subsidiary underneath it, and that subsidiary is the single member LLC. And what's unique about this form of entity, in contrast to a corporation, is that it has sort of a split personality. That for tax purposes, for federal tax purposes, this new entity is a tax nothing. It is not treated as separate and distinct from its parent. It is disregarded separate from its parent. And so therefore, when it comes to reporting federal income tax, this new single member LLC will not file a separate 990. Its activities will simply be reflected on the 990 of its parent. Likewise, for the same reason, the single member LLC does not need to apply for tax exempt status. In fact, it can't apply for tax exempt status and retain its status as this disregarded entity. So you could, so one of the benefits from a planning perspective is that you can set these entities up very quickly without having to go through the same formation and qualification process that you would with a new 501c entity. So they provide a lot of planning opportunities, a lot of planning advantages. And again, for tax purposes, federal tax purposes, they will just be treated as an extension of the single member. But at the same time, under state law, they are treated as separate entities. And so you're getting that benefit of liability protection because under state law, which is where your liability claims would typically be governed by state law rather than federal tax law. So the state will respect this new LLC as an entity that is separate and distinct from its member. So you've now moved this new property or this new activity into the single member LLC. If there's a claim, some type of legal claim that is generated in connection with that property or activity, the claim would be against the LLC, not against the parent that owns that LLC. So you've got the liability housed underneath the parent without reaching the assets of the parent. But you didn't have to treat it as a separate entity for tax purposes. And so that's, it's a little bit of a, you have to sort of split your thinking when it comes to these entities, but it is very useful and important. As we mentioned here, flexible management. LLCs are really, they're governed by state statutes, but the applicable statutes are much more flexible than corporate statutes, and so you can really structure the management of those LLCs however you want. Last point on this slide, consider local law for property tax exemption, which simply means that when it comes to property taxes, which are a feature of state tax law rather than federal tax law, depending on the jurisdiction, the applicable property tax laws may or may not respect LLCs or other types of entities like that as entities that would be eligible for property tax exemption. And then finally, for this part of the section, concept of a for-profit subsidiary. Again, if the activity that's being moved to your new entity is something that ultimately you determine is not consistent with your tax-exempt status, well, then a for-profit sub may be the way to go. You're conceding the tax issue there, right? You're no longer trying to get this activity under the protection of tax exemption. You're saying, okay, we acknowledge and we agree that we're going to have to pay taxes on this entity, but rather than paying it as UBIT out of your tax-exempt entity, if you move it into a for-profit sub, that entity would pay the tax, and if it's formed as a corporation, any dividends that then go up to the tax-exempt parent afterwards would not be taxable to the tax-exempt parent. And a for-profit sub, because it is not subject to the rules and restrictions of 501c3, offers certain types of flexibility that you wouldn't otherwise have. Equity-based compensation for executives, or if you're seeking to invite outside investment from other parties can invest in your for-profit subsidiary, whereas they could not invest in your tax-exempt entity.
So let's turn now to look at a couple of possible system structures. And then and then Don will sort of fill us in on how Whitman Walker dealt with this. So let me start with the first model, which is a very simple. This is the one most people come to us for. They're a nonprofit today, and they simply want to add in an entity to either hold their endowment or a separate fundraising entity. This is the simple parent-sub model, a parent with an underlying foundation. Now, let me make one point here about liability, because what people usually want this structure for is for a couple of reasons. One is they want the endowment in a separate entity to protect it from claims against the parent. Now, does that work? Is that real? And the answer is kind of. So it's always better to have your money in a separate entity, because that means you got to go after the separate entity. If you want to try, let's use a simple model. Let's say the parent's a hospital and their endowment's in the foundation, and something goes wrong at the hospital. Can I get the money in the foundation? Again, the answer is maybe. So, because here's what happens is I sue the parent, the hospital, where the thing went wrong. Well, my money's in the foundation. That's a separate legal entity. That has its own money. Is it responsible for the obligations of the parent? Well, first of all, you'd have to bring the foundation into the lawsuit, and you'd have to claim that the foundation's money is responsible for the parent's problem. So that makes it more difficult already to get at the foundation's money. But the reality is, here's what could happen. If I sue the parent, and the parent doesn't have enough money to satisfy a judgment, a court may very well say, well, you know what? Parent, you got to satisfy that judgment out of anything you own. And what do you own? Well, guess what? You own that foundation. So it's possible that a court will say, even though you've put these in separate entities, it's possible that a court could make the foundation responsible for the problem of the parent. But it's going to be a lot tougher. It makes it a lot tougher for the plaintiff to get there. He's got to prove that that foundation should be brought into the lawsuit. He's got to prove that the foundation should be responsible for the claim. It's tougher. So this is generally a very popular and good model. Now, if you want to take a few steps to better insulate the foundation, the thing holding the money, for the liabilities of the parent, there's some things you could do. In the normal world, what you'll see most commonly is the parent appointing the board of the foundation. That gives the parent control of the foundation, because the parent's going to be nervous. They're going to say, look, if I'm putting all my money in this foundation or in the endowment, whatever you want to call it, I'm worried they're going to walk away. I want to make sure I can get that money when I need it. So if I make it too independent from me, I run the risk that it could go rogue. So typically, you're going to have the parent appoint the board of the foundation. That gives you the most control. But with control, you're raising the specter of liability. Could somebody say, wait a minute, the parent can get at that thing whenever it wants, make it responsible for the parent's ills? So you're sort of trading off control for liability protection. A second model you could use, but I will tell you that is the most common model. A second model you could use is the parent doesn't appoint the board of the foundation, but they have overlapping boards. So on the bylaws of the foundation, we'll specify that the chair of the board of the parent and the president and the CFO are automatically on the board of the foundation. The parent doesn't appoint them, but they're on the board. And that gives them a seat in the room. So that helps ensure that the foundation doesn't walk away, doesn't go rogue. But you do give up a little level of control because there are only so many overlapping board members, and the parent doesn't control necessarily the non-parent board members on the foundation board. Third model you see, and this is the best from a liability protection, but you run the risk that it could go independent. I've seen ones where the foundation is freestanding. The parent doesn't appoint its board, and it doesn't have an overlap. But what they do is they populate the board of the foundation with quote-unquote friends of the organization. These are tend to be former board members of the parent. And you say, look, we don't control it. We don't appoint them. We don't have any seats there. They're totally independent. But we have friendly faces on that, and that helps make sure that it doesn't go rogue. That one's the best from a liability standpoint, but again, it runs a little bit of risk that it could be a little too independent for the parent. But that's the simplest model and the one that most people immediately gravitate to. Now we'll talk to a second model, which is this is the one this is the one the cool kids have. This is the one you see. So Yossi, you want to walk through that one?
Sure. So here when we've got multiple entities doing multiple things. The parent, as we said before, maybe your flagship entity, your school, your hospital, et cetera, conducting activities, or it may be set up with this oversight role to actually monitor the activities of its various subsidiaries. You've got the foundation there all the way on the left that would typically be conducting the fundraising activities for the system as a whole, not only on its own behalf, but to then provide support to the other affiliates, both up to the parent and then down or across to the other entities. Sub 1 and sub 2 sort of fill in, based on your imagination. It depends on what the activities of this system are. Maybe one of those is another 501c3 conducting a different line of activity, funding research or something like that. Maybe one of those is a for-profit, if you've created a for-profit activity in your system. And then the real estate holding company on the side, again, could be the C2, the C25, or maybe a single member LLC. But again, what you now have is a more fully developed system where each entity in the system is fulfilling its role, its function, and you create more specialty among each of these entities. And again, typically what you would see in the corporate documents for these entities is some type of overlapping rights where the bylaws of the foundation of sub 1 and sub 2 all identify certain activities that those organizations cannot take absent the approval of the parent. And the parent bylaws would likewise have mirror provisions stipulating its rights with respect to each of those subsidiaries.
Right. Now, keep in mind here, what's interesting about this model, and the reason that we like this model, from a liability standpoint, as I mentioned to you, liability sort of runs up and down. If something goes wrong at the hospital, you can reach down for liability to things it owns, things that are under it. What's neat about this model is by having a horizontal model of brother-sister corporations, those brother-sister entities are not responsible for their brothers or sisters. So if something goes wrong in this model at sub 1, sub 2 is not in privity with sub 1. So it gives you greater liability protection. And that's why you see this model being used quite often. Let me show you a third model, which we're starting to see more of, to be honest. And it goes to this liability question. And what people are saying is, look, what you're telling me is that if something goes wrong at my operating entity, I can now reach down to things underneath it to satisfy a judgment. So let me put the entity that has all the money on the top. I'm going to move the foundation up to the top. Because if something goes, let's say in this model 3, that the parent is the operating entity. Well, if something goes wrong, you can only reach down. You can't reach up. So you've now insulated your money by putting the foundation at the top. So from a pure liability standpoint, this model has a little bit of an appeal to it. But I'll tell you that people find it a little weird to have their foundation as the penultimate parent in the system. They're going, wait a minute, that's not the people I want running the system. I want the people who understand operations running the system. So I don't want the ultimate control to be in an entity that's really a fundraising or an investment entity. I want the real control to be in my operating entity. So I will tell you, this is a model we're starting to see more of. It's one worth considering, but it's got some issues with it that are worth thinking through. Now, let me turn now to our friend Don, and who has lived through all of this in more than he ever cared. And Don, I'm going to turn this over to you to walk through what you've been through and survived, and maybe some helpful tips to those considering.
Thanks, Bob and UC. I'm grateful to be here. I'll try to share some the good, the bad, and the ugly of what we've been through over the last about 2.5 years. And as you can tell, in real life, you plan and then things happen. And so if you look at the community health system chart in front of you, it does not look like any of the slides uniformly that my dear colleagues on the panel have presented. There are some nuances related to Whitman Walker that I'll have to share with you to let you know why we landed in this place. But first and foremost, to move from the legal construct and framing that my colleagues shared with you, is Whitman Walker exists solely to serve the community as a nonprofit. And so why would you even undertake something like this? Well, there has to be a core mission, opportunity, or challenge. Because otherwise there's a lot of work, a lot of money, and a lot of time that could be better spent doing other things to advance our mission. And so we do stuff from a place of mission always, because that's the most important thing. The second is the issue of who we are. We are in our 45th year as a nonprofit. We have been surviving what is now our 5th decade of change. In the 70s, we were gathering space for gay men and lesbians at a time when society would not let people be out. In the 80s, we were a volunteer-driven organization as the first responder in this region, the AIDS epidemic. In the 90s, we became what is colloquially known as an AIDS service organization, largely fueled by Ryan White Care Act at the federal level. That's when we really scaled up in employees and sites programming and ran everything from direct patient care to housing to food bank to legal services and having easily more than 1,000 volunteers in buddy programs and other type of activity. In the late 90s to early 2000s, we moved with the advent of the antiretrovirals, which has been the singular biggest probably medical intervention in 100 years, short of a polio vaccine. Those medications are keeping people alive longer, which meant our model had to change. And during the 2000s, we faced, what do we do with a model that was about dying with dignity, which would now be living with a chronic condition that has significant stigma and discrimination. I'm happy to share with you that one of my colleagues, former colleagues, Nicole Greenwich Hoskins, helped us navigate that process in the mid-2000s, and I want to recognize Nicole's here. It takes a village to do this work, and Nicole is one of the better ones in our village, so thank you, Nicole. The last 10 years has really been about, pardon my French, the dog catches the bus. We are about 5 times the size we thought we would be. We have been fueled by the Affordable Care Act. We have been fueled by extension of benefits, particularly locally and federally, around queer communities, particularly the transgender and gender fluid communities, for access to a host of services, which 20 years ago public and private insurance wouldn't cover. So now the scary part of our job is we have over 21,000 patients. So we're about 4.5 times the size of the number of patients when I first started about 15 years ago. So just scale is enormous. And so we are now operating something that I don't think any of us ever imagined, and it's grateful to be able to do this and work on behalf of community, but it's scary as heck. And the reality of this is that at 21,000 patients with 23 programs, 300 employees, 500 volunteers, 6 sites, federal research, federal grants, third-party, public and private payers, I mean, we just have a complex business model that warranted some real serious consideration. The first issue that came up was really, how are we going to fund this thing long term? And many of you in the nonprofit space, we're chased with, we're always challenged with sustainability issues. And so you're looking at an entity that, in Whitman Walker's case, on the direct patient care side, that needs roughly $700,000 to $800,000 a year to cover kind of health benefit, pay, utility, and other traditional cost increases. So we would have to turn, in effect, almost a 0.5 point of operating surplus every year just to cover the basics. And so when you go through a growth period, in our case, we were growing more than 1,000 patients a year for a 5-year stretch, we needed $1 million a year because we were adding staff. And so we're sitting here going, when in our nonprofit existence have we been able to turn $1 million a year every year, year after year? And it's just that wasn't there. And so some really long and hard conversations about, well, how are we going to do this, particularly in the climate we're in at the federal and local level, and how much money is available for nonprofit support. And so I won't bore you with the long and short of how we landed there, but we made ultimately a decision to take a look at the single biggest asset that we had, which is the real estate that our health centers sat on. So we were operating on really valuable space. The easiest one and parcel to point at is the Elizabeth Taylor Medical Center at 14th and R Street Northwest. Conservatively, that was worth, on a fee simple sale back in 2013, about $25 million. And so we could have sold that off and in using one of the structures that Bob and Yossi outlined, put all of that away in an endowment and garnered 5% a year. That 5% a year on $20 million after we pay all the recordation fees and everything else for the sale would only contribute about $500,000 or so. So there was no real room for growth long term to be able to grow programs and be responsive. It would help us pay with inflationary pressures, but it wouldn't really allow us to be responsive. And so we elected to hold the property and ultimately go into a for-profit business in a joint venture real estate redevelopment project with a firm called 5 Squares based out of Bethesda, Maryland. 5 Squares principals are Ron Kaplan and Andy Altman. Some of you may know Andy's name. Andy was a former director of planning here under Tony Williams, under Mayor Williams, and had a lot to do with a bunch of the activity, including City Center and the early planning of that. And Andy's claim to fame is really about how do you take, how do nonprofits actually use the assets they have to be able to give back to community and also generate some financial sustainability long term for your operations. So we've been in partnership with them since 2015. And so this notion of us going into business with a developer on a for-profit activity clearly raises a litany of issues that Yossi and Bob outlined. Charitable status, control, flow of funds, management, leadership, governance issues. Okay, who's controlling? Is management controlling this? Is the board controlling this? And so, really having to do the due diligence of sorting through that. In our case, the liability issues were probably paramount. And so when we started exploring the different options, and I was grateful because Bob and Beth Caseman, who was here, and others supported us during that early process a few years ago, we looked at these different iterations of options and ultimately felt like our core asset and the single biggest thing that's going to keep Whitman Walker going long term is the rental income from the joint venture. We have to figure out a way to protect it from medical malpractice and employment lawsuits. And we also have to have access to it so that the entity that is controlling it doesn't go off and starts spending lavishly and holding all of their board meetings in Switzerland. And so we had to figure out what those dynamics were. So with the board decision to do this joint venture, the board tasked me with what other questions should we be asking if we're going to have to restructure the company. And I have some previous life in subsidiary models. So I started looking at all of the different elements that we have within the 23 programs, which things are under federal oversight or grant funding and which things aren't, and made a recommendation to our board to pull everything out that wasn't federally funded, with the idea that Whitman Walker doesn't want to go through a corporate restructuring every 3 to 5 years. We, in fact, have never done one until the one we've done in the last 2 years. But we want to do it really thoughtfully, and the principle was do what you do best. So it was really to some of Bob's points about trying to get the right people in the right place so that they're singularly focused, okay? And so do what you do best is a common model when you have a complex business operations. At a certain point in time, you split off into divisions, units, companies, and the issue is integration. And so I'll spend a little bit of time on integration, but I want to make sure I cover that. Now, a word about this structure that's on the PowerPoint on the screen. So on the far right, Whitman Walker Clinic is the nonprofit. It's a 501c. It's been in existence since 1978. That's our direct care. That's where the patient care and most direct service is provided. The entity below it is a 501c3. It's called the Hearth Foundation, and that is a HUD Section 8 grant for 12 housing units for persons with disabilities. That was entered into 22 years ago and has 18 years left on it. And HUD required a separation from the clinic so that the HUD funds weren't commingled with the clinic activity. And so that's a function of a federal award. On the left side is what we ultimately constructed with Venables' help, which is really the notion of what we would use in academia or in healthcare, in academic medical center, which is this notion of a health system model. And so we have the parent company is Whitman Walker Health System. That is an 11-person board that has six non-clinic board members and 5 clinic overlapping members. Sorry, I have to get the language right. You'll see on the graph that there's some overlap, and that gets back to some of the control and influence issues. We wanted the separateness. We also wanted different expertise. The clinic is known as a federally qualified health center in healthcare parlance. That is a particular requirement to have 51% board member composition. So we have to have patients comprising 51% or more of the clinic's board, and that is a federal requirement. The clinic also, as an FQHC, has to have independence and autonomy to hire, fire, coach, and counsel its CEO, and to make programming, service, and hours of operations decisions. Those are formal requirements that the federal government mandates you to meet. And so in this model, if Whitman Walker is not an FQHC, it's likely a subsidiary under the health system. That's where we probably would have landed, which I think was option 2 as presented by Bob and Yossi. So we've got the parent as the health system, an 11-person, and then working the foundation, a pure philanthropic arm, a 501c3, can have up to 18 board members. It has 6 right now because we're in year 1 and in the formative years. It's absolutely a fundraising entity. It is to a 509A supporting entity back to the system in the clinic, and I'll come back to the relationship between the clinic and the health system. The middle entity going horizontally is Real Property Holding, and that's Whitman Walker's interest, and I believe, Yossi, you covered this. Below that is the for-profit business, which is a Delaware-based for-profit, and like most developers, we have a really sexy name. It's the address of the project. And then the other Whitman Walker entity that we formed in this process was the Whitman Walker Institute, and that's our knowledge and learning arm, and that houses our research, education, and policy advocacy work. That has a board of 5 members right now. 1 is a clinic board member and 4 others. And so this structure on the system side, if you would, is really about the strategic advice, the larger business decisions, and fund development. And then lastly, and most important is from day 1, which is risk management, risk mitigation. And so that's the construct on the sister side, on the system side. On the health center, I've got this board overlap. I want to talk a little bit about the relationship. So we've talked about it as sibling. I've lived this now 2 years. It's a marriage. It's not a sibling relationship. It's absolutely a marriage. And so any of you who are partnered or married, you know exactly what I'm about to tell you. It's far more difficult than you think. There's absolutely a honeymoon period, and then you get into the nuts and bolts of having to get the kids to school every day. We just have the challenges of having to run an entity that for 45 years has been basically on its own, solo, doing whatever it wants, largely with management having far more influence over what we do than the board. Let's be honest. A lot of the nonprofits, it's the management that's doing this, not the board. In this model, this yields a lot of power and decision-making to whom? The new companies. The new companies now hold the single biggest asset and income stream, the joint venture, hold the philanthropic activity in the foundation, and have some ability to generate a small amount of surplus on private and publicly funded research grants. So a lot of the margin generation or income side is actually now sitting over in the health system side. So that, as you can imagine, made the clinic board a little nervous. And so we had to address what I would consider some, I don't want to say that this is a prenup, but it's got the feel of that. So in addition to board overlap, there's 2 other areas of integration that have just been ridiculously important, and we've relied on already. And so we like the board overlap. We think it's really important. We never want the health system companies to go rogue from the clinic. And we also are worried that the clinic won't value what the health system is doing. It's really important to think about the health system as a set of startup companies and the clinic being here forever. And the clinic is, I apologize, I have New England roots. It's time to make the donuts. It's Dunkin' Donuts every day. It's the post office. There's 600 patients every day coming to the clinic, and that's hard work. It takes a lot of our staff, and so they're over there in the operating side going, wow, this is really hard. And then you have a set of new companies. that are trying to generate funds, provide advice, and then obviously oversee some really important asset value. And so board overlap, really important. We think it's critical to make sure that this thing stays together. We actually have informally figured out succession planning on who moves from where and who goes to which company, because that cuts back on that future risk of entities going in different directions. The second area is we absolutely developed a shared leadership model. And in this model, there are two CEOs. There has to be, by federal requirement, a CEO of the clinic that reports directly to the clinic board and no one else. That person was my former deputy. That person now is Naseema Shafi. She's been with Whitman Walker about 12 years now. I serve, effective earlier this year, as the CEO of the health system. What Naseema and I were asked to do by our boards was to come up in writing with how we do our work together. And so, again, that was like writing up our work marriage. We literally had to put on paper, how did we do this? We proposed that to them formally, and what the board ultimately supported is Naseema, as the CEO of the health center, works 25% of her time for me. I, in turn, work 25% of my time for her. And we have actually duties that we owe each other and responsibilities. We don't work for each other's boards. We work for each other. That's a function of our relationship, but it was also a way to connect the leadership or the management of the company. In the case of Naseema's obligations, they're around some of the real estate and some of the research elements. On my side, back to the clinic, it's some of the financial management, rate setting, and leadership, because Naseema is a new CEO. It's her first year in running Whitman Walker. And so the second level of integration was the shared leadership model, which we really believe in. We think single leadership models and models like this are just too complicated, and that there's no one person who actually could do all of this. And so we just want to be mindful of that. And then the third area is just the kind of financial integration. And this is where I can't thank the Venable team enough. We had some good advice both from Baker Tilly and from BDO USA, our audit partner, in working through, well, the clinic, in deciding to do the joint venture, moved its single biggest asset over to the health system side. So it moved book value of about $7 million off of its balance sheet. And the clinic board's saying, what do I get in return over time? And so we've put the property in a joint venture, which for 4 years means there's really no income coming off of that. And it's also not available to do any debt collateralization for the clinic should it need an operating line of credit or what have you. And so what we ended up doing is saying, well, we're going to enter into what is known as an affiliation agreement between the clinic and the health system. The health system has a requirement to throw off 70% of its net assets, assuming it achieves net assets every year, back to the clinic for a 5-year period. That's the low end. It's capped at $2.5 million. And the idea being that if 70% of net assets up to $2.5 million goes back to the clinic for the first 5 years of this system, the clinic is more than made whole for the transfer of the $7 million book value to the health system. I'm sorry if that was too much finances for y'all, but you need to know it's really important because the clinic's giving up its asset and it's been holding on to that security blanket for 45 years. Okay, so I want to be mindful of that. The second area that we did financial integration is on, and Bob referenced this, we didn't want to start out with a massive amount of administrative load or overhead. And so we did a shared management services agreement between the clinic and the health system. And so the health system right now has one employee, it's me. All of the other people working in the health system are shared from the clinic, albeit there's 10 to 20 of them who are almost 80+% of their time in the health system. And that's particularly true for people who help us raise money and people who help us do the clinical trials. And so that's the long and short of the integration: board overlap, shared leadership model, and financial integration through the two tools, the affiliation agreement and the management services agreement. So let me tell you a little bit about how it's working. Again, you plan and life happens. The entity in its first year combined was able to break even with all of the costs to structure this. So the clinic and health system, even though we don't consolidate because they're separate entities, actually generated about a $500,000 margin on about $96 million in total revenue. The entity now through May 31st is running at about $1 million. And that's because the health system side is getting some of its elements up and running in year 2. And the clinic has been able to do what it does best and focus on the things it needs to focus on. And so this model needs to continue to go for about 3 more years, where the foundation and the institute largely drive the fund development activities of the system, because the rental income really doesn't kick in until 2021. So the joint venture, we have refinancing, we have a bunch of activity. The project comes online this year. We'll refi in February of 21. We won't see significant rental income really till that year. And so we had to build a bridge from the time to build this system to support the joint venture that made the clinic still okay financially. And so this is the model we worked on. The last thing I want to just share is just things about people. So people hate change. This is massive change for any organization, even people who are sophisticated business people. Half our staff, their eyes roll over when we talk about this, but there is a clarity about this that's easier for people to understand. The people working in the clinic now don't worry about all these other things. And we have mechanisms by which we communicate how this work is going on. The board members on the Institute have a family of companies meetings so that once a year they're with the clinic board. Once a quarter they're with all the boards on the system side. And so we've developed those internal communication, because you have to have connectivity, because this thing's only going to work based on relationships. As much as I love legal structure and financial framing, it's about people. And so people don't like change, people don't like complexity, and new things just, people's anxieties come up, so we've had to manage that. What I've really loved about this, it has instilled an energy and a sense of entrepreneurship that we oftentimes don't see in the nonprofit sector. And so this is really forcing us to think differently about how we operate. We're now a $100 million operating company combined, and we have a $145 million joint venture. So Whitman Walker's activities is involved in almost $250 million of activity. It's just, we would have never imagined that. And so this is a good place for me to stop and say, again, thank you to Venable and the team. They were amazing to work through on this. I have the great joy of leading this for another 3 years, and then my time will come to an end at Whitman Walker, which is, it should come to an end. I've been there a long time. And I've singularly stayed on because I believe that this, or a version of this, is how we deal with the sustainability issue. We were never going to be able to find a funding model that didn't have some use of our assets as a big part of it. We barely break even on federal grants and on third-party payments. And to see more patients every year and not have the funds to invest in people, our employees, and the programs and the facilities long-term, I mean, for me, that's a basic issue of a lack of respect or a lack of dignity for the people we serve. So be a good place for me to stop.
So, Donna, thank you. So I want to open this up to all of you in the room for questions and those of you on the webcast. But, Donna, let me take the prerogative of asking the first question. So, because I think, and I've seen this, and I think it would be great to hear from you on lessons you learned on A, how you brought your board along with you on this process, and second, how did you communicate this to your constituent community?
So on the first one on the board, there was a natural evolution because of where our growth was post-Affordable Care Act and some of the challenges we're facing. So we were having financial swings because of growth. We'd have really good years, not so good years, and it's just like, okay, they're looking at leadership, at management going, help us figure out the business model that makes this thing work long term. And the feast and famine thing is a terrible thing for nonprofits. We live it too often, and it's really bad for us emotionally. And so we're trying to tackle that issue. The joint venture, at the end of the day, seemed to make the most sense. And we didn't have an immediate capital need. We didn't have a site or a building that we wanted to acquire, which would have been the logical choice to sell our property on 14th Street and just to use that to purchase something. And so not having that need, there really was this thought of like, okay, what could we do with that asset long term? And from there, we use, at Whitman Walker, we use ad hoc committees pretty frequently. We have that in our bylaws. And so we had a subset of board members originally look at health system. And we did that in 2016 and 2017, which led to this model. And then in 2018, we worked a a board ad hoc committee on shared leadership with Nasima and me. So we did it in 2 phases. We didn't try to do everything at once. We did the joint venture first and got that structured. Then we did what should be the corporate structure. So that's part 2. And part 3 was, okay, what's the leadership model long term? Trying to do all of these things together will overwhelm a board, let alone management. And on a personal note, it was a lot for me. And I'm really old and I've been through a lot. And it was hard to work through. The other issue is it's always about transparency and trust. If people's interests aren't out on the table and aren't communicated regularly, people don't trust one another, no one will ever be able to pull something like this if there's no trust.
Question?
Alan Irish, American Coatings, great program. Appreciate this. I was intrigued. This is probably for Yossi. I was intrigued with the discussion of endowment, and I was just curious if you could talk a little bit more about that. In particular, how you fund the endowment. Can you, for example, take organizational money, say a chunk of your reserve fund, and shift it to that, or does it have to be sort of on-purpose fundraising? Do you have to have people give money specifically for the purpose of that? Funding that endowment?
Yeah, that's a really important point, and the answer is both. That if you're creating a new endowment entity, 501c3, and you have existing endowment assets in your original organization, those assets can move over to your new endowment entity, and the mechanics of it would really be as a grant, right, from one 501c3 to another. But one of the important things to be mindful of, and certainly in terms of maintaining donor relationships, is that anything that's held for a restricted purpose in your original organization, those donor-imposed restrictions, right, if you received a targeted grant, right, or a gift from a donor pursuant to a gift agreement saying that these assets have to be used for A, B, and C, well, moving those assets over to your new endowment entity, all of those restrictions would go along with it, right? It doesn't free up assets to be used for a different purpose that they could not have been used for out of the original organization. At the same time, and this I guess becomes a little bit more of a question of fit and feel. As far as ongoing fundraising activities, you could conduct those future fundraising activities out of the endowment entity, just have contributions go straight in there. Mm-hmm. You could do it out of your operating entity and move those assets over periodically, sort of differentiating between contributions for operations versus long-term, planned giving or endowed gifts. So that I think comes down a little to more of the specifics of the particular organization.
Right. Okay. Thank you.
Question?
Yeah, hi. I just had a quick question, and it has been extremely helpful. For the Institute, what was the rationale behind having that a separate entity as opposed to funneling that activity somewhere else?
That's a great question. So part of the challenge within the clinic's operating model is activity that's really valuable from a mission perspective but doesn't directly affect patient care. And research education, we would argue in some respects legal does, but there are questions within our staff sometimes does it or doesn't it. There was some real thinking about, well, if they stay within the clinic's umbrella portfolio of programs, will they get the attention? Will they get the investment of resources? And every annual budget process for 15 years, research, legal, education, they can't compete because we always need one more nurse, medical assistant, psychiatrist, addictions counselor, and that's the right place for the board to be, and it's the right place for management. So we basically, from our perspective, had something that was really important and unique, but that wasn't ever going to get the sunlight and kind of rain that it needed to be able to really grow in the garden. And so there was that element. And then I'd love to tell you that my team is always altruistic about our life. There are some pricing and grant benefits to having private trials and federally funded grants under a different entity with a different overhead load. So the clinic's overhead load is about 24%. Traditional research institutes run between 40 and 60. So by keeping it in the clinic, we were basically hurting ourselves. So there's just a financial reality of if we move this stuff out, we can create direct and indirect rates that are going to generate a little bit more money to cover a second level activity from a mission perspective and do it at in effect, what was a net cost to the entity to do it. And so that was our rationale. The other is just from what I would call a voice and kind of social justice impact. It's much easier for us to have an institute that has a board and is out doing policy advocacy work, in some respects outside the clinic. It protects the clinic from political retaliation.
Question?
I was very curious about the real estate holdings entities that you discussed and all of the benefits specifically of the single member LLCs. And it seemed to be maybe more attractive than the corporate entities. And I was wondering, with the advent of the single member LLC, you mentioned that becoming more and more common, what are the scenarios under which someone would still choose that a corporation would be more advantageous for their situation?
So the thing, your question are, in essentially, have LLCs replaced these title holding companies? And by and large, they have, is the short answer. There are unique circumstances where having the title holding company makes more sense. Because if you think about it, the LLC is a disregarded entity. So everything that happens in the LLC gets treated up on the parent's tax return. And that, generally, that's a good answer. Occasionally, it's not. And there are some very specific reasons where you want to do one. For example, in our situation, in the Whitman Walker, where the real estate venture was so large, having it collapse up into the parent could be problematic. So in their case, having a separate corporate structure to shelter between, a blocker in effect, made sense. But in the normal run-of-the-mill world, you will see LLCs basically supplanting these sort of title holding. LLCs are great. I mean, they just are. They're so easy. You don't have to go to the IRS, so you can do it, and all the cool kids have them. You can talk about it at parties. It's really good. But, yeah, you see those largely replacing title holding companies.
So I want to add a kind of an operational reality to the model we have. And, again, grateful for the team's support on this. We have been able to take in 2 significant investments of low-cost capital through this structure, which we never envisioned when we put this together. And so we have 2 entities that did program-related investments, give us low-cost money, and we have taken out a lot of the higher-cost construction debt. And so this version of having the JV for-profit entity with some type of holding interest on top of it, when we put this together, we never envisioned going down that path. And yet here we are where 2 significant entities have invested heavily, and we are not paying a penny on that for 9 years. They've given us the money. We have paid off debt. We owe them at refinancing, at second-level refinancing by that date. And our cash flow projections show we pay them off in 4.5 years based on the current pro forma. So this model actually financially will generate about $3.5 to $4 million in cash for the system that can then go back to the clinic. And so notwithstanding the technical issues of should it be an LLC or what have you, this particular model had a really interesting benefit for us that I don't think we ever imagined. Private or family foundations wanting to invest in our real estate project as a different way to support Whitman Walker. And so it's really interesting. The clinic is very happy about that development. We did not see that coming, and it's a very good one for us financially.
Take one more question.
Hi, Don, thank you for your comments, particularly around the use of task forces, which I found to be really helpful and enlightening. My question is about the shared leadership model, and you mentioned that you and Nassima don't work for each other's boards, but for each other, and I'd be fascinated to hear 2 things. One, how CEO assessments works in that environment, and then anything else that you'd like to share with respect to your belief in the model.
Thanks. It's a great question. What I love about my colleague is that she and I share a similar element around humility. We really do understand what we don't know, and trying to take the best of each one of us to put together a model. And quite frankly, if this were to scale, we could see CEOs of the foundation and the institute long term and really thinking through what that looks like. And so the practical side of this is trying to take what each one of us has as really the gifts that we might bring to the table and figuring out a way to actually allocate time formally. So how do we do this? In her 25%, she has 10 for research in the Institute, 10 for real estate oversight with me, because she's been working on all of our real estate projects for the last 8 years. And then 5% with the health system as an advisor. In effect, having another voice for the clinic to be able to say, hey, health system, these are the things we need support on. On my time, I have 10% for financial management and rate setting, 10% for government relations, particularly locally, because I've had that role for 13 years. And so those relationships won't convey quickly, and I'll need to help her with that. And then 5% kind of coaching and counseling as a new leader. And they're formal designations, they're time allocations, they're in our management services agreement. It's a board-adopted activity. And then we structurally do it through time management. And so that's a really important part of it. This is the first year that we're operating it, so we haven't gone through the CEO assessment. But we operated last year like this without the formality. And so for both mine and for Nasima's evaluations, both boards had the ability to contribute to that. And so there'll be a process where particularly the board members that overlap on the two will have the ability to be able to do that bridge. And so the way we're planned to do the evaluations this year is the board chair of the system and the board chair of the health center will work jointly on both of ours. And that way they'll bring, in effect, this is the value that the joint model works. Here's what we want to share back to the two companies about how it's working. And again, it's our first formal year doing this. We may make changes to it, but this is how we've operationalized it.
Just one more point on the LLC question from a moment ago. Something to be aware of is that even if you find yourself in an organization or feel like, oh gosh, these systems, these restructurings way beyond our scope, as Don said, you plan, and sometimes things come along unexpectedly. Another use of single-member LLCs for that property holding function is if someone makes a gift to you, and the gift is an asset, real property or otherwise, that for whatever reason might have some liabilities associated with it, the organization might think about setting up a single-member LLC, even without a broader restructuring, just to hold that particular asset. For many years, it had been this open question within the industry, does a contribution to a single-member LLC, where the LLC is owned by a charity, is that eligible for a charitable deduction? Finally, the IRS came along and they said, yes, it is. And so in situations where an organization is taking in a gift of a complex asset, real property or otherwise, that might have certain risks associated with it, just forming a simple LLC to receive that gift can often be an important planning technique.
So I want to thank you all for coming today. I hope you realize we've been doing this for a number of years, and I hope we can convey the pleasure we get in providing these sort of education. It's kind of, the thing I get the biggest kick out of is my alma mater, which I barely made it through. I think they probably are more amazed, which my parents didn't bribe for me to get in, but they use our materials at school, which I find great. Really want to thank Don. I mean, it's just, Don is a humble guy, but I think you can get from the experience that the qualities of patience that it takes to get to there and just hanging in there is really incredible. Our next one of these will be on July 18th, again on maximizing your native advertising and use of social media influencers for nonprofits. We invite you to join. Thank you again for coming. For those of you who post questions through the webcast, we'll get back to you separately on those. But thank you all. Have a great day.